Good afternoon, class. Today I'm going to talk about the Second Amendment. As Robert E. Shalhoub notes in The Ideological Origins of the Second Amendment, disagreements over gun legislation reveal disparate perceptions of the American society that rest upon or inspire dissimilar interpretations of the Second Amendment. Now, depending upon one's political worldview determines how one interprets this amendment. Now, the leftist crowd would have everyone believe that the Second Amendment only applies to those involved in a state militia, and therefore excludes private ownership, especially in the home. For example, on Mother's Day of 2000, 750,000 protesters gathered on the National Mall near Capitol Hill as part of the Million Mom March, demanding tougher gun control laws. And acting as spokeswoman, left-wing actress Susan Sarandon reminded the audience that the Second Amendment was a product of a different world and a time period where a musket, not an AR-15 assault rifle, which, by the way, is an oxymoron, was the weapon of choice of a well-regulated militia. So in a nutshell, the continuing debate over the Second Amendment pits supporters of an individual's right to gun ownership against those who believe the Bill of Rights only protects the right of the state to maintain a well-regulated militia. Boiled down essentially to two terms, the debate concerns individual versus state use. Prior to the Supreme Court's 2008 decision in District of Columbia versus Heller, the courts had yet to conclusively state what right the Second Amendment protected. The opposing theories were, one, an individual's rights approach, meaning the amendment protected an individual's right to firearm ownership, possession, and transportation, and number two, a state's rights approach, under which the amendment only protected the right to keep and bear arms in connection with organized state militia units. Now, for rabid anti-gunners like Susan Sarandon, Charles Schumer, Dianne Feinstein, the fact that there no longer exists state-regulated militias is quite convenient because that means, at least to them, that no one has any business possessing a firearm unless they are a member of a state militia, like Triplets Virginia militia who fought at the Battle of Cowpens in 1781. This line of thinking is analogous to prohibiting someone from possessing a Roman gladius unless that person intends to join a Roman legion. Of course, the passage of time has obviated that possibility as there are no more Roman legions. However, the Supreme Court has now definitively held that the Second Amendment does indeed protect an individual's right to possess a firearm unconnected with service in a militia and to use that weapon for traditionally lawful purposes such as self-defense within one's home. Moreover, this right applies not just to the federal government, but to states and municipalities as well. In the Heller case, the Supreme Court held that 1. The District of Columbia's total ban on handgun possession in the home amounted to a prohibition on an entire class of firearms that Americans overwhelmingly chose for the lawful purpose of self-defense, and thus violated the Second Amendment. And 2, the district's requirement that any lawful firearm in the home be disassembled or locked up with a trigger lock. That also violated the Second Amendment according to the Heller case because the law made it impossible for citizens to use said firearms for the lawful purpose of self-defense. The court reasoned that the amendment's prefatory clause, i.e. a well-regulated militia being necessary to the security of a free state, announced the amendment's purpose, but did not limit or expand the scope of the operative clause, that is, the right of the people to keep and bear arms shall not be infringed. So, what does infringed mean? Does that mean I can keep a bazooka in my house for home defense? Saul Cornell in The Second Amendment Under Fire, The Uses of History and the Politics of Gun Control argues that, like most rights, the Second Amendment right is not unlimited. It's not a right to keep and carry any weapon whatsoever for whatever purpose. For example, concealed weapons prohibitions have been upheld under the amendment or state equivalents. Also, the court's opinion should not be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons or the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools, government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. Political and legal debates over the meaning of the Second Amendment will continue at rallies, in legislative halls, in the media, and in courtrooms throughout the United States. And there is no getting away from the fact that all such debates will continue to rely on conflicting understandings of the past.